Hello everybody. We are group number 4. Presenters are Nick, Matt, Jenny, James, and Eric. Today we're going to talk about Chapter 13, Civil Rights and Employment Discrimination, Chapter 14, Criminal Law, Chapter 9, Torts Privacy, and Chapter 12, the Employment Agreement. Let's start with Chapter 13, Civil Rights and Employment Discrimination. I'm going to talk about overview, Title 7 of the Civil Rights Act of 1964, other anti-discrimination laws, intellect use of age discrimination, the current cases in May 2018. So let's go to the overview. Civil rights legislation helps ensure that every member of society has the opportunity to reach his or her full potential and promote economic growth by expanding the pool of qualified workers. The abolition of slavery after the Civil War and the civil rights movement of the 1960s were two great forces behind modern civil rights legislation. Let's talk about employment discrimination. In a specific area of employment law, several federal or state acts provide for protected classes based upon innate characteristics. A specific area of employment law, several federal and state acts provide for protected classes based upon innate characteristics. Employment discrimination law protects employees who fit into these classes. The major pieces of civil rights legislation as a federal law, we will begin with the Title 7 of Civil Rights Act of 1964. This is the most well-recognized anti-discrimination law. Why? Because it prohibits discrimination in employment on the basis of race, color, religion, national origin, or sex. Later amended to provide that discrimination on the basis of sex includes discrimination on the basis of pregnancy, childbirth, or related medical conditions. Litigation in traditional Title VII actions has produced two distinct legal theories of discrimination. Disparate treatment, which is a plaintiff claiming disparate treatment must prove the employee intentionally discriminated against him or her, but denying a benefit or privilege of employment. Disparate impact, which cases are typically Title VII class action brought against large employers challenging testing and other selection procedures, claiming they systematically excluded women or particular ethnic groups. Background checks during the hiring process. Sex-based discrimination. Title VII prohibits international discrimination by an employer. Sexual harassment, hostile work environment, Equal Pay Act, Pregnancy Discrimination Act, and dress code. Racial, national origin, and religious harassment. Religious discrimination is intentional conduct or policies that treat or affect individuals differently based upon their religious beliefs or affiliations. This includes any of the international discrimination, such as failing to hire, firing, or allowing different benefits. Negligence. An employer is negligent with respect to harassment if the employer knew or should have known of the harassment but failed to stop by taking appropriate corrective measures. And retaliation. Title VII and other statutes prohibit both employment discrimination and retaliation against an employee for exercising his or her protected rights. We also have other anti-discrimination laws. We have Civil Rights Act of 1866, which prohibits racial discrimination by employers of any size in the making and enforcement of contracts. Equal Pay Act, 1963, mandates equal pay for equal work without regard to gender. Age Discrimination in Employment Act, which I'm going to talk about one of the current cases on May 2018, protects people 40 years and older from discrimination on the basis of age. The Older Workers Benefit Protection Act prohibits age discrimination in providing employee benefits and establishes minimum standards for a waiver of one's rights under the Age Discrimination in Employment Act. Vietnam-era veterans, which also affirmative action to employ disabled Vietnam-era veterans. The Rehabilitation Act of 1973 prohibits discrimination against the physically and mentally disabled. Uniform services employment gives employees who serve in the military at any time the right to be reinstated in employment without loss of benefits and the right not to be discharged without cause for 1 year following such restrainment. We also have immigration reform, what prohibits discrimination against applicants or employees based on national origin or citizenship status. American with Disability Act of 1990, as amended in 2008, prohibits discrimination in employment on the basis of a person's disability. Family American Leave Act of 1993 prohibits employers' group health plans. Patient Protection and Affordable Care Act, which prohibits insurance exclusion for pre-existing conditions, facilitates comparable coverage. The Equal Employment Opportunity Commission is the primary enforcer of civil rights legislation in the United States. As a part of the Department of Justice, the Equal Employment Opportunity Commission processes thousands of complaints investigating and evaluating their merit. Adverse employment action. In most discrimination cases, the employee must establish that his or her employer is subject to an adverse employment action. Remedies. Available remedies in discrimination cases generally include compensation for lost salary and benefits. And lastly, affirmative action. Affirmative action is a federal executive order prescribed to protect federal employees and employees of certain federal contractors. So, let's go to our current case. Intel accused of age discrimination. U.S. federal investigators are looking into Intel's layoff of 12,000 employees since 2016. Intel, one of the grand old statements of the tech world, is under investigation for potential age discrimination in its approach to layoff initiated in 2016, according to a new Wall Street Journal report on May 25, 2018. Intel sought to get rid of older employees and retain younger ones instead that benefits the company. 2 years ago, announced its layoffs and restructuring. Dozens of former employees sought legal advice on whether they could sue, or some of them lodged complaints with the Equal Employment Opportunity Commission. 2,300 layoffs. The median age was 49 years old, 7 years older than the median age of the remaining staff. It's now up to the Equal Employment Opportunity Commission to make a determination on the merits of the complaints that it has received. If the federal watchdog finds sufficient grounds to pursue the matter further, it can initiate a class action lawsuit against Intel. People should take action. If they think they have been discriminated against, they can file a charge with the Federal Equal Employment Opportunity Commission. They can also work with a lawyer to file a lawsuit. Before taking either of these steps, consider going through your company's grievance system if this has one. Next, chapter 14. I'm going to pass over James.
Thanks, Jenny. Chapter 14 covers criminal law, and I would like to start by explaining the foundations of this chapter. First, what is a crime? The textbook defines a crime as an offense against the public at large, or any act that violates the offender's duty to the community for which the offender must make satisfaction to the public. A crime can be categorized as either a felony or a misdemeanor. A felony is a crime that's punishable by more than 1 year imprisonment or by death. Some examples of felony are murder, or examples from the book include computer crime fraud and abuse, or mail and wire fraud, among others. Next, a misdemeanor is a less serious crime. It's punishable by either a fine or 1 year or less in jail. Examples of misdemeanors are speeding tickets, trespassing, or vandalism. Now that we defined what a crime is, let's discuss the elements of a crime. First is actus reus, which is a Latin word for the criminal act or wrongful deed. What it means is that a crime is not committed unless a criminal act has occurred. Quoting the textbook, merely thinking about a criminal activity is not criminal. The next element of a crime is mens rea, or the state of mind. The key to this concept is the criminal's mental state, or their knowledge that their actions or lack of actions would cause a crime to be committed. There are three categories within mens rea. They are negligence, which is the failure to see the negative consequences or harm of an action that a reasonable person would see. Next is recklessness, which is essentially knowing of the harm but ignoring the risk and carrying out the crime anyway. And lastly is intent. This is where a person can foresee the consequences of their action, yet they desire it to happen. It's important to note that both elements of the crime must be present to create criminal liability. For my current event, I chose to highlight the crime of tax evasion through the recent news regarding Cristiano Ronaldo. The background of this case is in 2017, professional soccer player Cristiano Ronaldo was accused of defrauding tax authorities 14.7 million euros, which at the time equated to 16.5 million US dollars. The accusations against Cristiano Ronaldo were knowingly using a business structure to hide income between the years of 2011 to 2014, and voluntary failure to comply with his tax obligations in Spain. You'll notice I use quotes around the words knowingly and voluntary. I did this to emphasize my discussion of mens rea, as the prosecutor would be tasked with proving that Cristiano Ronaldo had the state of mind to know his actions would commit a crime. Of course, Cristiano Ronaldo's response was to deny the allegations, claiming there has never been any hiding nor any intention to hide anything. Before we continue with the current event, let's revisit the concepts from Chapter 14 that I covered earlier and use them as a sort of a checklist for the event. First, speaking of the definition of a crime, an offense against the public was committed in the form of tax evasion, so we can check that box. Next, what type of crime would this be? Based on the dollar amount that Cristiano Ronaldo is accused of evading taxes, which totals 16.5 million US dollars, this would fall in the category of a felony. Next, we move to the elements of a crime. When we think about actus reus, the criminal act of tax evasion was committed, so we check that box as well. But what about mens rea? Was Cristiano Ronaldo's state of mind proven that he was negligent, reckless, or exhibited intent? Again, the burden of proof would be on the prosecutor to prove this in court in order to convict Cristiano Ronaldo of tax evasion. So now we fast forward to current day in the current event with the news that broke on June 15th, 2018. Cristiano Ronaldo accepted a plea bargain deal from Spanish officials to settle the case with the following terms. He was fined $21.8 million and received a 2-year prison sentence. However, it's unlikely he will serve actual jail time because Spanish law states that a sentence under 2 years for a first-time offense can be served on probation. So how did we get here when we just established the prosecutor must prove mens rea to create criminal liability? We can infer that Cristiano Ronaldo knowingly committed tax evasion since he entered into a plea bargain, proving he had the state of mind or mens rea. The textbook explains that a plea bargain involves the prosecutor lowering the charges or fines in exchange for a guilty plea, which is how I came to this conclusion. We will see if more details come out about this case in the weeks or months to come to further examine how they relate to Chapter 14 in criminal law. Finally, I'll leave you with the following guiding questions for the discussion board. Question number 1. Cristiano Ronaldo was accused of allegedly hiding the income from his image rights. What effects will the recent tax evasion settlement have on his image, marketability, and future endorsement potential? Also, please discuss the ethical components of this decision for a player with a reported net worth of $400 million, committing tax evasion on funds of roughly $16.5 million, which is a mere 4% of his net worth. Question number 2. I focused on the mens rea component of the crime for my current event presentation. Please provide your thoughts on which element of mens rea, negligence, recklessness, or intent that you feel was violated in this case and explain why. I will now turn the presentation over to Eric. Thank you.
Thank you, James and Jenny, for your presentations. My name is Eric Marino, and I am going to cover Chapter 13, Employment Rights and Discrimination, and Chapter 14, Criminal Law. The reason is this case actually straddles both chapters. You could even make the case that there are some elements of Chapter 9 and torts as well. But for the brevity of this discussion, we will only focus on those two chapters. So, By now, most of you have been bombarded by this in the news. On October 5th, 2017, the New York Times ran an article alleging decades of sexual harassment against Harvey Weinstein. And since then, it's been nonstop. Many of you have probably seen multiple articles and are a little confused as to, who's suing who and, what type of charges there actually are against Harvey Weinstein. So I hope to clarify that in a brief timeline. So the subsequent fallout after this article has launched multiple lawsuits, including one class action and two criminal investigations in the Me Too movement. There's actually two aspects of the civil and criminal case in this topic. So these are just some of the topics that relate to this course throughout both chapters. The first being sexual harassment, specifically quid pro quo harassment. So sexual harassment obviously is a violation of Title VII on the basis of sex. And quid pro quo harassment is adverse action such as the denial of a promotion, retaliation for a person's refusal to respond to a supervisor's sexual advances. Another topic is employer and supervisor liability for hostile work environment. Employer liability for the actions of an employee. Specifically in this case, negligence, where an employer was aware of sexual harassment but failed to stop it. The criminal procedure, beginning with the arrest through the plea, and racketeering under the Racketeer Influence and Corruption Acts, otherwise known as RICO. I was a little surprised by this having being the basis of one of the civil lawsuits, which we'll talk about in a second. I posted a brief timeline here. Most of these came from the BBC, except where I've noted. So on October 5th, 2017, the New York Times ran an article alleging decades of sexual misconduct by Harvey Weinstein. So if you don't know already who Harvey Weinstein is, he's a Hollywood producer who allegedly used his position in the Harvey Weinstein Company to either sexually harass or sexually assault over 80 women. So for reference, a producer is someone who controls the development and financing of a motion picture. Basically, they control what gets made and to some degree who stars in it, as you'll see in the Ashley Judd case coming up. November 28, 2017, a civil claim in the UK issued against Harvey Weinstein. December 6, 2017, lawsuit seeking class action is filed against Harvey Weinstein, Miramax, and the Weinstein Company and members of its board, including a local person, James Dolan, who is the owner of the Rangers and the Knicks. February 11, 2018, New York State prosecutors file a lawsuit against the Weinstein Company. May 1st, 2018, actress Ashley Judd files a lawsuit against Harvey Weinstein. May 25th, 2018, Harvey Weinstein is charged in New York State with rape and several other counts of sexual abuse against two other women. June 5th, 2018, judge rules class action lawsuit can resume. And that is the lawsuit that was filed on December 6th. So, the class action lawsuit, this is the one that was filed on December 6th. The plaintiffs in this case allege that the Harvey Weinstein Company perpetuated and concealed Weinstein's widespread sexual harassment and assault. So, from vaguely, even though these allegations are tantamount to civil racketeering, clearly the Weinstein Company created a hostile working environment for the women, a clear breach of their rights under Title VII. In addition, the Weinstein Company was negligent in their duty to protect these women against the improper conduct of Harvey Weinstein, an employee of the Weinstein Company. So, some definitions. Civil racketeering is defined under the Racketeer Influenced and Corrupt Organizations Act, also known as RICO. From Bagley, in a private civil action, the statute grants a civil private right of action that permits individuals to recover treble damages, that means 3 times, and also cost and reasonable attorney fees. So basically, whatever the actual damages were, the plaintiffs are entitled to 3 times that plus the cost of their attorneys. Negligence from Bagley. An employer is negligent with respect to harassment if the employer knew or should have known of the harassment but failed to stop it by taking appropriate action. The thing I found interesting about the RICO aspect of this was that we're used to hearing about it from the mafia, not from a civil suit aspect where somebody's actually suing an organization because they're engaging in some type of nefarious activity. So Ashley Judd's lawsuit. Ashley Judd is suing based on retaliation in response to spurning Weinstein's sexual advances. Normally this is difficult to prove, but director Peter Jackson has corroborated Miss Judd's story by stating a casting decision was actually made directly from the information provided by Harvey Weinstein. In addition, she is suing for violating California's unfair competition law, a state law that broadly written to protect against defamation. So basically, Peter Jackson wanted to cast her, and Harvey Weinstein said, "Don't do it, she's difficult." And a decision was made based on that. And that was because, obviously, Ashley Judd did not want to have sexual relations with Harvey Weinstein. So, defamation from Bagley is the communication to a third party of an untrue statement asserted as fact that injures the plaintiff's reputation by exposing him or her to hatred, ridicule, or contempt. And retaliation, from Bagley again, prohibit both employment discrimination and retaliation against an employee for exercising his or her protected rights. In this case, Ashley Judd did not want to have sexual relations with him. Sex crimes charged from New York State. This is the actual criminal charge. The other two were civil suits. This means he will actually wind up going to jail if he is found guilty. Harvey Weinstein has pleaded not guilty to the charges of first and third degree rape and first degree criminal sexual act. The charges were brought after a grand jury indictment. The first victim claims Harvey Weinstein grabbed her head and forced her to perform an oral sex act in 2004. The second victim claims to have been held against her will and forced to have sex. Harvey Weinstein is currently out on $1 million bail. So, arrest. Harvey Weinstein surrendered himself to New York Police Department. At this point, Weinstein is booked, taken before a magistrate, informed of the charges, and bail is issued. In this case, he was also indicted by a grand jury. Now, normally what happens is if an arrest warrant is issued, the police need that if they have to go into the suspect's home to arrest him. If he's out in public, they don't actually need it. In this case, they probably did, but he turned himself in under the advice of his attorneys. So the next steps would be a plea bargain, a trial, and sentencing. So to start the discussion off, what do you think will be the outcome of this criminal trial? So some things to consider. Remember, just because the court of public opinion has rendered him guilty, a jury has not. Case in point, the first Bill Cosby trial, which ended in a mistrial. Second, if in fact he is found guilty, how do you think that will impact the civil lawsuits, both current and future? In other words, if it was just a civil lawsuit and he wasn't convicted of an actual crime like rape or sexual assault, do you think it would impact the current civil actions against Mr. Weinstein and his company? That's my presentation, and I now pass it off to Nick.
Thanks, Eric. And with that, we'll continue our discussion with torts and privacy protection. So, what are torts? Essentially, torts are civil wrongs that result in personal injuries to individuals or property. They are usually initiated by the injured party and are different from a crime, which are wrongs that are done to society and persecuted by the state. For this chapter, I thought a great case to review was the Facebook and Cambridge Analytica scandal. It's a classic example of an invasion of privacy through intrusion. And the invasion of privacy that was committed was essentially Cambridge illegally broke into user data of Facebook profiles in order to further their corrupt business practices. And then they later published this information to third parties to help align their goals. Another concept that was broken in this scandal was the concept of fraudulent misrepresentation. And essentially what fraudulent misrepresentation is it's either a defendant's conscious act to alter specific data that a plaintiff needs in order to act properly in a situation, or if a defendant outright lies or bends the truth to get a plaintiff to act in a certain way that's beneficial to the defendant. These actions can have fiduciary violations as well, as if stakeholders don't get the proper information they need to act, they could suffer monetary loss as well. One of the biggest breaches on Facebook's part was in the act of negligence, or their clear and apparent lack of judgment with regard to security for their customers. In particular, they committed actual cause, as their actions directly resulted in damages to their customers, and proximate cause, as they owed a legal duty or had a legal obligation to defend their consumers from data breaches but failed to follow through. One of the biggest breaches in this case is the breach of the California Online Privacy Protection Act. This act for California residents includes certain requirements that ensure the safety of the personally identifiable information of California residents and consumers. This information can range from first names and last names to social security numbers. And while this act does not require entities to honor consumers' choice to not be tracked online, it does require entities to disclose if their personally identifiable information can be collected by other third-party organizations after customers use this site, something that Cambridge Analytica clearly breached. Another rule that was broken in this case was the FTC disposal rule, which essentially is a rule that requires certain organizations that compile personal data to have measures in place that can delete this data if it is no longer necessary to keep or if it has been compromised. And this was something that was clearly breached in the Facebook Cambridge Analytica scandal. Also, in the European Union, the Data Protection Directive that was enacted in 1995 also serves to help defend consumers' data. This requires companies that do business within the EU to register with their Protection Supervisory Authority, and it deems that personal information should not be collected unless it is not excessive, transparent, and has a legitimate purpose to being collected. The GDPR that was previously discussed in this class, helps to enhance this by making one unified rule for all states, and it also expands the type of data that's protected. So, to specifically talk about this case, Cambridge Analytica, which was essentially a British political data analytics company, illegally took the Facebook information of thousands of individuals to help promote the marketing campaigns of specific individuals like Donald Trump during the 2016 presidential campaign. And this was done through through Cambridge Analytica's app, This Is Your Digital Life. Another interesting fact was that other candidates, such as Ted Cruz, may have unwittingly used such tainted data to get their points across. And this case concluded with the operating closure and Chapter 7 bankruptcy filing of Cambridge Analytica. They announced their closure on the 16th of May, and on May 18th they filed for bankruptcy. So, Cambridge Analytica, their founder, Alexander Nix, who's the guy on the top left here, was accused of false advertising and promoting deceptive business practices to frame their clients into performing actions to help Cambridge's business operations. Many people like to call him a Bond villain. I prefer to call him Dr. Evil, who's the guy on the top right there. And he was even caught on hidden camera admitting that he could entrap political rivals with beautiful Ukrainian women, essentially through sex bribery to help blackmail these individuals into performing acts that would benefit Cambridge. And this was confirmed by Christopher Wiley, who was a former employee turned whistleblower. He testified on April 24th in front of Congress. So, specifically, about 87 million people had their data stolen by Cambridge Analytica so that their data could be used in psychographic voter profiling for marketing campaigns that were used during the 2016 election for Trump. And essentially, what psychographic profiling is it's when the online information of an individual is taken to create tailored marketing campaigns towards individuals that would either prey on their desires and wants or their fears to get them to perform actions, specific political actions. And in June of 2014, Cambridge Analytica hired Professor Alexander Kogan to extract this information through their This Is Your Digital Life app on Facebook. Essentially, Alexander Kogan created a questionnaire, if you will, that would notify respondents upon entry that their data would be compiled for academic purposes. However, this was a clear lie, as this data was also used for political purposes by Cambridge Analytica, but they did not disclose this to respondents. And additionally, respondents' friends list activity on Facebook was also accessed, and specifically the friends within their friends list had their data pulled as well and used in this profiling, and they were not notified at all. To make matters worse, it was confirmed that former Trump campaign strategist Steve Bannon used this information to dissuade Democrats from voting in the 2016 election, by preying on their fears through marketing campaigns. Robert Mercer, who is a prominent hedge fund manager, also had an owning share in this company, in Cambridge Analytica, to ensure that he could influence political happenings within the nation. It's also speculated that Russian officials may have also gotten their hands on this data, as Alexander Kogan was working on other projects of a similar nature at the same time as when he was creating the Cambridge Analytica app survey. And these actions clearly violated the California Online Protection Act of 2003 and the European data rules that were discussed previously. Facebook engaged in gross negligent actions that served as actual and proximate causes for Cambridge Analytica's data breach. Gross negligence is clear and apparent lack of urgency and care, resulting in significant damages. Facebook showed clear signs of this through their delayed implementation of improvements of weaknesses that were in its privacy policies since 2007. They were forced to improve these deficiencies after a 2011 FTC review required 20 years of third-party checkups, as well as these adjustments. Alexander Kogan himself expressed confusion with Facebook's old policies, and was even frustrated by their lack of urgency when asked for clarification. Facebook was aware of Cambridge's corrupt practices since 2014. Because of all this information, influential followers such as Cher have dropped their Facebook accounts entirely to coincide with the hashtag Delete Facebook movement on the social media website Twitter. In fact, I myself have seen Will Ferrell drop his Facebook account for this purpose. As another interesting fact, Facebook's chief technology officer admitted that Facebook did not read all the terms and conditions for the apps that used the Facebook platform. Facebook claimed to have asked Cambridge to delete the questionable content that was taken, but even though Cambridge said that they had in fact deleted this data, Facebook did not take the proper steps to properly confirm that their words were true, which was a direct violation of the FTC disposal rule. This was a mistake that Mark Zuckerberg has openly admitted to. As of now, Facebook has banned Mr. Kogan from the platform, agreed to notify users who may have been affected, and announced that it will audit all apps with similar types of personal data access. As of April 30th, 2018, Facebook is now battling 36 class action lawsuits. And with that, I'll turn the presentation over to Matt.
This is Matt, and I will be focusing on Chapter 12, the Employment Agreement. Over the course of my slides, we're going to look into some aspects of the employment agreement and your rights as employees. Focusing on the 4 bullet points below, we will start with an overview. The overview will talk about different types of contracts that you enter into when you're working, as well as your employee rights. Then we will talk about OSHA, the Occupational Safety and Health Agency, which enforces the Occupational Safety and Health Act. Then we will talk about the Employee Retirement Income Security Act of 1974, also known as ERISA. And lastly, the Fair Labor Standards Act, which was a law enacted in 1938. Okay, so to start, I just wanted to begin by looking at types of employment contracts. The most popular type of employment contract is an at-will employment. At-will employment essentially states that an employee can quit at any time. It also states that an employer can also fire an employee at any time. In both cases, this can be for any or no reason, with or without advance notice. Now, there are certain state exemptions that exist to help protect the employer in an at-will employment environment. The implied contract exemption is where workers are employed at will, but there may be rules and regulations in their contract or a statute in the employment handbook that advises that employees will only be fired for just cause. Also, there is a good faith exemption. Certain states that adopt the good faith exemption are essentially always required to only terminate for just cause, regardless of whether this information is outlined in an employee handbook or not. Then going on lastly to the public policy exemption. The public policy exemption essentially states that an employee can be defined as wrongfully discharged when a termination violates an explicit, well-established public policy of the state. This could include, for example, going out on workman's compensation when you get injured at the job and your employee fires you. A public policy exemption would protect the employee from losing their job. Not subject to at-will employment are public employees who usually can achieve tenure, individual contracts, which we see very commonly with temporary employees that are hired for 3 months or 6 months at a time, with the expectation that at the end of that contract it is known that they can be let go and released from their duties, or they can be extended. And finally, union workers. The union fights for the workers and usually always requires that there be just cause in an termination. The federal agency, OSHA, the Occupational Safety and Health Agency, requires employers to establish safe and healthy work environments. OSHA is authorized by Congress to regulate all workplace safety issues up to and including hazardous chemicals, protective gear, fire protection, workplace temperatures, ventilation issues, and employee health standards. OSHA inspectors can conduct inspections at any time without warning within a reasonable hour. OSHA also has a hotline set up for workers to report hazardous work conditions, which the workers are protected by whistleblower laws. Whistleblower laws prevent employers from committing violations by retaliating against workers. OSHA also has an established fine system for workplace safety violations. The maximum penalty for serious violations is $12,471. The maximum penalty for willful and repeat violators is $129,336 per offense. To show an example of how OSHA levies fines when they find violations, let's look at a recent current event involving OSHA and TPI Composites. The Iowa OSHA office issued $154,524 in fines against TPI Composites, a company that manufactures wind blades. OSHA's complaint alleged safety issues, which included fire hazards, fall hazards, and a lack of employee training on using protective equipment. This substantiated workers' claims that TPI did not protect them from the hazardous chemical epoxy resin, which subsequently caused severe skin injuries, which you can see pictured below. 6 of the employees are now filing a lawsuit against TPI, claiming that they reported that they had developed an allergy to chemicals since being exposed to epoxy resin. This, they claim, made them unable to work with chemicals, therefore unable to work for TPI Composites. The lawsuit now is in effect and being supported by OSHA, who provided a 40-page document substantiating the workers' claims. Now let's focus on the Employee Retirement Income Security Act, also known as ERISA. ERISA is a federal law which is enforced by the United States Department of Labor. What ERISA essentially does is protect employees in conjunction with the fiduciary standard, a standard which requires that financial advisors place the interest of their investors over their own. Regarding pensions and how ERISA protects their pensions, they do the following. They establish minimum funding requirements and participation standards. They impose fiduciary obligations on advisors. They also require detailed disclosure and reporting of certain pension plan information and require administrators to provide annual audited financial statements to the government and the participants in the retirement plan. They also impose substantial restrictions on the investment of pension plan assets, which at your workplace usually equates to a minimum percentage that you can contribute per paycheck. This way you're not giving them too much, and therefore you're reducing your risk by minimizing how much you can actually give. Example of ERISA, let's take a look at current event news. Recently, it was reported that Invesco, one of the largest employer-sponsored retirement programs in the United States, is the latest target of an ERISA self-dealing lawsuit. Now, self-dealing is when a fiduciary acts in their own best interests before the client's best interests, which is essentially the opposite of what we know the fiduciary standard to be. In this complaint, the plaintiffs say that the defendants put their interests before the plan participants' interests by treating the plan as an opportunity to promote and generate fees from proprietary investment products offered by Invesco and their subsidiaries. Additionally, the complaint reports that during the class period, between 93% and 95% of the plan's investment options were affiliated with Invesco. Many of the plan's investment options performed worse and/or had higher fees than other comparable unaffiliated investment options. Now, the typical 401k plan usually has between 10 and 15 investment options. The complaint also accuses that Invesco intentionally flooded plans with options to confuse investors on what were the best options to pick. The complaint refers that there were approximately 150 to 205 options offered in this particular plan during the class period, and that Invesco also routinely offered poor performing retail shares over better performing institutional shares. In the end, the complaint asks that the lawsuit will seek to recover all losses resulting from defendants' breaches of fiduciary duty and other ERISA violations, and to restore to the plan any profits made by the fiduciaries or the persons and/or entities who knowingly participated in the fiduciary's imprudent and disloyal use of plan assets. Fair Labor Standards Act, also known as FLSA. The FLSA was established in 1938, and its purpose is to regulate minimum wage, overtime pay, and any age restrictions that may exist in the workplace. Currently, the federal law for minimum wage stands at $7.25 an hour, although in certain states they have enacted state laws that have this minimum wage higher. The FLSA also makes sure and states that all hours worked must be paid to the employee. This includes regular work and then overtime. Now, there may be a few designations that are exempt from overtime. The exemptions include this: they must be paid a minimum salary amount, they must be on a salary basis, and they must meet the duties test for this exemption. The FLSA and state laws that manage and patrol possible labor violations. Recently, Cheesecake Factory was ordered to pay $4.57 million to the janitors that work for their subcontracted cleaning company for wage theft. A California Labor Commission investigation found the following violations. Workers were forced to work from midnight until morning with no breaks. Workers were detained after shift and not allowed to leave until the subcontractor, Magic Touch Commercial Cleaning, conducted an inspection of the restaurant. The inspections often led the workers to staying and performing unpaid tasks. Investigators determined that the unpaid tasks completed amounted to 10 extra hours of unpaid overtime per week. In California, there's a bill that exists called the California Senate Bill 588. This holds all parties accountable for any labor violations. This means that Cheesecake Factory, along with the subcontractor company Magic Touch, is responsible for paying workers the back unpaid overtime pay. Now let's focus on the Employee Retirement Income Security Act, also known as ERISA. ERISA is a federal law which is enforced by the United States Department of Labor. What ERISA essentially does is protect employees in conjunction with the fiduciary standard, a standard which requires that financial advisors place the interest of their investors over their own. Regarding pensions and how ERISA protects your pensions, they do the following. They establish minimum funding requirements and participation standards. They impose fiduciary obligations on advisors. They also require detailed disclosure and reporting of certain pension plan information and require administrators to provide annual audited financial statements to the government and the participants in the retirement plan. They also impose substantial restrictions on the investment of pension plan assets, which at your workplace usually equates to a minimum percentage that you can contribute per paycheck. This way you're not giving them too much, and therefore you're reducing your risk by minimizing how much you can actually give.